I apologize for misleading all of you. The last panel was not the most controversial panel we're going to have. That was on whether or not rich people should get their education financed with education savings account. This time we're going to say, should the government, should we have organized religion paid for by the government? That's the question, and that should be controversial. So, 50 years ago, this was a no-brainer question, right? Separation of church and state, Jefferson said that. Whether it's in the Constitution or not, we don't know, but Jefferson said it, so we must believe it. So that was the way it was 50 years ago. Supreme Court sort of, done a somersault. And the latest stuff coming down from the Supreme Court is open to a lot of interpretations, one of which is that you must fund religious schools if you're going to fund secular schools. So we've got a panel that's going to consider this question in the context of charter schools. And it's a very distinguished panel, and Martha Fields from the Harvard Law School is going to open the discussion. William Jeynes from the California State, did I get your?
You got it perfect.
Okay. From William Jeynes from California State University, Long Beach is going to then be second, and Mike Moreland, Villanova, will wind up. And we're going to try to keep you all to 8 minutes. Is that sufficient? And you're used to having a judge say, this is it, and then they come down with a hammer. So I won't have a hammer, but just about the same. So, Martha, please begin.
Thank you. Thank you for inviting me to this very interesting conference. I wrote down some of my remarks so I wouldn't talk, but I thought it was 5 minutes, so I will.
Oh, we need to turn your mic on.
Oh, okay.
And we need to get you right up against the mic. Oh, Michael, make sure, stay around now, don't leave, and make sure that it's coming through clear. Yeah.
I wrote down my some of what I'm going to say because I didn't want to go over what I thought was a 5-minute limitation. Anyway, I hope that we won't talk too much and that we'll leave adequate time for questions and comments from the rest of you. Anyway, of all the reversals of precedent we have seen from the United States Supreme Court, none is more pronounced than its reversal on the relationship of church and state. During the Warren Court years and beyond, the court, quoting Thomas Jefferson, said that the First Amendment of the U.S. Constitution created a wall of separation between church and state. Many of states had already adopted that approach in their constitutions. In Everson versus Board of Education in 1947, the opinion said that it espoused the wall of separation between church and state, and all of the justices agreed on this characterization. There was no dissent. The Warren Court went on to prohibit prayer in public schools, the posting of the 10 Commandments in public schools, the providing income for building of church buildings, and other demonstrations of the wall of separation between church and state. This movement was characterized as the separationist view of the First Amendment's Establishment Clause. Gradually, during the 21st century, this view was challenged and eventually replaced by a majority of the court with a neutralism view of the Establishment Clause. It changed from separationism to neutralism. This interpretation said it was discriminatory to exclude churches from generally available public benefits. Accordingly, if a state gave money to public schools to build buildings or to provide computers, It had also to give money to religious schools. The same must be provided to religious schools. At first, however, there was a limitation that church schools not use the benefits to teach religious doctrine. That still was considered public funding of religion, contrary to the First Amendment. But in 2022, in Carson versus McKinn, the court obliterated the distinction between religious status or identity of religious schools and religious use of the money. Carson versus Macon involved a Maine town which, having too few students to justify a public school, instead offered vouchers to all students to attend any school they wished, private or public. They would pay the tuition even at the private schools. The schools could be in-state or elsewhere. Religious schools were permissible, only pervasively religious schools, as they called them, were not permissible. These were schools that taught through the lens of religion and through the lens of religious faith, schools that proselytized and who taught students to despise other religions. The Supreme Court held this religious use of funds did not disqualify the school in question from receiving students. So no longer was it that, that you couldn't discriminate against schools that identified themselves as religious schools, but you had to let them do whatever they wanted to with the money, even though that had not been allowed before. Now, Carson involved vouchers, not charter schools, but the clear implication is that religious charter schools, including those that preach religion and who teach hatred of other religions, will be allowed by the current court. Whether charter schools are called public or private, that will be the result from the United States Supreme Court. One such case has been litigated in Oklahoma, where a religious charter school has been proposed and fought for. The school would evangelize and discriminate against those who don't follow religious doctrines. For example, it would not allow openly LGBTQ students. They would exclude them, and a student would not be permitted to wear a hijab, though it was required by her religion. Same for a yarmulke for a Jewish student. The Oklahoma Attorney General challenged the school, and the Oklahoma Supreme Court held that it would violate state and federal law for the town to pay tuition there. I believe that if the Supreme Court decides to review it, and we're likely to know that in early October, they will reverse the Oklahoma decision and allow the religious charter school. Same for other religious charter schools, at least if they receive any public funding. I would not support such a decision, but I believe it is coming. I'm sure others on the panel will disagree with me about the merits of such a decision.
I think
well within the 8 minutes, I think.
you did a fantastic job, and you did a great job of clarifying the line of thinking that has evolved on the court. So thank you very much for that presentation. William, I think you're...
Thank you for inviting me, and thank you, Harvard University, for inviting me. I've had the opportunity to meet some of you. I hope to have the opportunity to meet more of you afterwards. But in any case, to answer this broad question of are religious charter schools constitutional, I would say yes, they are. But I think what is going to be very interesting, I do agree with you that the Supreme Court is going to rule that they are constitutional. The question, I think, that remains is in what context? Are they going to make a narrow decision, or are they going to make a broad decision? So an example of a narrow decision, which I think is quite likely, the U.S. Supreme Court might define religious charter schools as constitutional, but they might leave it up to the states as to the actual degree of implementation of these charter schools. And a more broadly defined decision would be, okay, if you have charter schools in your state, which is true of the vast majority of states, then you must offer at least the possibility of the existence of religious charter schools. Now, adding much momentum to this is a case that was already referred to, the Carson case, Carson versus Macomb case in the state of Maine, in which, yes, the state of Maine offered some vouchers to parents who desired to send their children to non-religious private schools, but did not offer these vouchers to parents who desired to send their children to private religious schools. And the ruling by the Supreme Court, it was 6-3, it was that this was discrimination. This was discrimination against schools of faith, and this really launched an increased level of momentum in favor of the discussion that we are having today. It wasn't the first time it's been raised. In fact, there was a previous case in 2020. It was in the state of Montana, and it was Espinoza versus Montana Department of Revenue. What was very interesting is Justice Stephen Breyer, in, again, 2020, he raised the question with that decision, what about religious charter schools? And that, again, really increased the momentum. But as significant as these cases are, there are three issues that were left unresolved by the U.S. Supreme Court and really do need to be resolved. The first issue is, well, yes, are religious charter schools constitutional? Okay, even as it was hinted at, as has been suggested earlier, nevertheless, there was no explicit decision on whether these schools were constitutional, and that needs to be addressed. It might even be the case that this Oklahoma Supreme Court decision might indeed go to the U.S. Supreme Court. We'll see, but my guess is if it's not this case, it'll be another in which the U.S. Supreme Court addresses these issues. A second particular issue that really needs to be addressed is the degree to which states can impose certain restrictions upon religious charter schools, and of course others as well, that they cannot participate in these programs, in the vouchers or funding, whatever else might be available. They cannot participate unless they meet certain requirements that may inhibit the religious school's freedoms and beliefs. Now, to what extent are they allowed to do that? And this issue was hinted at in the response by the Attorney General of the state of Maine, Aaron Frey, who after this decision was made, he said, okay, I just want to clarify for all charter schools, but we all know who he was aiming at in particular, in order to participate in this program and receive a voucher, they must abide by the state of Maine's Human Rights Initiative, okay, the Human Rights Act. And then, okay, we need to ask the question, and the Supreme Court needs to address this issue, to what degree will states be allowed to do this? And let's just assume they are allowed to do this. Where do we draw the line? At what point is it okay? What restrictions are okay? And what restrictions go beyond the line? And I think they need to be reasonably specific about this. So that's issue number two. And then the third issue, which I believe is so key in determining whether religious charter schools are constitutional, is does the U.S. Supreme Court view the actors running charter schools, does the Supreme Court regard them as state actors or as private actors? I think this will be the key issue, because after all, generally speaking, most charter schools are run by private groups, okay? You might say, well, on that basis, they're private, but they're defined by state law as being public. So some have even said it's almost a hybrid, if you will. In fact, some at the Brookings Institution have asserted this, that the reason why there's controversy in this area is that the private and the public meet, so how it will be defined. And what makes this issue more difficult is the court decisions that have been made thus far, they differ from one another. Let's be objective, they differ. So if you go to a 2010 decision in the Ninth Circuit Court of Appeals, and it was on a, can you fire certain educational employees without a state hearing, if you will, they declared that those who run the charter schools are private actors. And what is especially interesting, and I would argue especially relevant, that many people have overlooked, is they cited a U.S. Supreme Court case from 1982, Rendell Baker, the Rendell Baker versus Cone case, that did not involve a charter school, but kind of close to a charter school. They were a private school, especially designed to help struggling students, but 90% of their funding was government funding. So, ooh, that sounds mighty close to a charter school, even though it wasn't, so it's significant. They cited that to justify their decision that those who run charter schools are private actors. So if that's the case, if the U.S. Supreme Court decides similarly, and they might, because you know how the U.S. Supreme Court loves precedent, okay, and they might use the Rendell Baker case as precedent, if they decide that those who run the charter schools are private actors, they're going to declare, yes, religious charter schools are constitutional. However, the Fourth Circuit of the Court of Appeals had another case involving not firing certain educators, if you will, on the school staff, but it involved a school dress code. They declared in 2022 that those who ran charter schools were state actors, and of course, under that scenario, the schools have to be non-sectarian, and therefore the religious charter schools would be ruled, if the Supreme Court agrees with that, they would be ruled as state actors, and then religious charter schools would not be constitutional. Now, my prediction, just as my esteemed colleague has stated, my prediction is also that the U.S. Supreme Court will decide, you know, whenever that time comes that they do decide, they will decide that religious charter schools are constitutional. Thank you very much for your attention.
All right, thank you. Mike.
Yes. Well,
We had lots of Michaels earlier, but you weren't in the room perhaps, so
I'll answer.
this is always a challenge for me, as to
I'll
how to
answer
handle
either
a
one is
third
fine.
Mike, right? Professor Moreland.
Either way.
Yeah.
Well, thank you to Paul and to Dan for the invitation to be here, and for you all being here late in the afternoon here. I'll echo and recapitulate many of the things that my co-panelists have said. I do think that there really are at the core of this question about religious charter schools. There are kind of three questions. But the threshold question, which I guess the panel topic asked, is, are religious schools constitutionally permissible? I think the answer to that is yes. And in fact, I think in some instances, depending on particularities of certain state laws, I think religious charter schools are constitutionally required in some states. And so the first question is this issue that has been talked about a little bit already, and that is the free exercise clause issue with regard to whether or not the state in a neutral benefit program can discriminate against religious entities. And now for a decade and a half or so, the Supreme Court, in a series of cases, starting with a playground resurfacing grant program in Missouri, through Carson versus Macon in Maine, has made very clear that where the state has a neutral benefit program where it doles out funding to private institutions, it violates the free exercise requirements of the First Amendment for the state to then turn around and discriminate against religious actors. That in other words, you can't exclude religion because it's religion or because of the uses to which religious institutions might put those public funds. And so I think that is of course, there have been dissents in some of those cases. They're somewhat controversial. But I think at the core of that is a non-discrimination requirement that the Free Exercise Clause is meant to protect, and that those cases have upheld. Even Justice Breyer, in his dissent in Espinoza, the Montana case, said, well, what about religious charter schools? And I think a lot of people in response to that said, well, yeah, what about them, right? Because religious charter schools, and a lot depends on the public-private issues I'll talk about here in a moment as well, but religious charter schools in many instances operate in the same kind of way of being the beneficiaries of neutral state funding that the religious schools in Montana and Maine did in Carson and in Espinoza. The second issue then is, what about the Establishment Clause, the other part of the First Amendment? And Professor Field, of course, is correct that beginning with Everson in 1947 through the 1970s and 80s, the court engaged in a lot of, in my view, bad history, bad understanding of the Establishment Clause, highlighted the separationist principle that was only a shred of evidence from a letter that Thomas Jefferson wrote to the Danbury Baptist Association. Remember, though, even in Everson in 1947, while adopting the separationist rhetoric, the court upheld a busing program that provided bus subsidies for parochial school students in New Jersey. So even in Everson itself and in the subsequent cases, sometimes the court allowed the provision of funding to go in the interests of religious schools, students attending religious schools. Again, I can't, in our short time here remaining, say all that would be needed to be said about this history. I commend books like Philip Hamburger, the legal historian at Columbia's book Separation of Church and State, that argues for why this Warren Court and going into the Burger Court era precedent on establishment was bad history and has rightly been rejected now by a majority of the Supreme Court, saying that, again, where the state is providing a benefit to parents and children, it does not violate the Establishment Clause for parents and children then to use that benefit in turn in a religious environment, including, I think, a religious charter school. The court has said that now for over a quarter century, going back to the Zellman-Harris case that upheld the constitutionality of the Ohio voucher program. They are saying that the independent choices that parents and children make to use public benefits for religious purposes does not violate the Establishment Clause. And so I do think that you have, on the one hand, if you will, the kind of sword of free exercise and its non-discrimination requirements, and no longer the shield, if you will, of the Establishment Clause saying that the state can't provide those benefits because of separation of church and state. But to echo one more thing that Bill already pointed out, a lot here, of course, depends on what are charter schools. And this may vary sometimes on what the provisions of state law say charter schools are. In most states, my understanding is, I guess about 45 states have charter school provisions. In most states, charter schools operate as government contractors. For-profit corporations, nonprofit corporations can run charters in many states, including in Oklahoma, where this litigation has mostly recently arisen. There is a for-profit corporation operating an online charter school. And so just because Boeing, by entering into an agreement to produce airplanes as a government contractor for the Pentagon, doesn't become a state actor thereby, nor do these entities, these charter schools in many states, I think, turn into state actors for purposes of First Amendment analysis merely because they're entering into a government contract. Now that, of course, may change in some states. It may be that perhaps in response to this challenge, maybe some states will make charter schools truly government-run public entities. But I do think that part of the charter school movement, of course, was to have choices for parents and kids that weren't totally reliant on school districts and the provision of education through public school districts, and to provide those alternatives, art schools, STEM schools, classical education schools, and whatnot. And I do think now, for both reasons that are constitutionally permissible and probably constitutionally required, that should include religious participants as well.
So let me ask the first question. The Wall Street Journal reported this morning, and I'm sorry I haven't read the case, so I don't know the details, but I understand that it's the court of last resort for the state of South Carolina, I think it is, and they decided that ESA programs, Education Savings Account programs, the monies from those programs cannot be used to pay tuition at private schools, which struck me as exceedingly interesting, given the fact that all three of you have agreed that if it's a private organization, then clearly Carson applies, and this would be constitutional. Susan, do you want to start the conversation? Have you had a chance to reflect on that decision?
Well, just from what you said, I think it doesn't violate Supreme Court doctrine to say that if the money can't be used at private schools in general, that includes religious schools. I think maybe why, the idea is that if there is a public benefit available to private schools, that that it also must be available to religious schools. But one alternative the state has is to not allow it at private schools at all, and maybe the reason they didn't was because of the problems that we've addressed before. I did want to disagree with Bill on a couple of points, if I may do that now.
Yeah, go ahead.
First of all, in Macon, Carson v. Macon, Maine did allow religious schools to receive the vouchers, but the only ones that they didn't allow were ones that proselytized and discriminated, what they called pervasively religious private schools. Now, the newspapers misreported this over and over to say that no religious schools were allowed by Maine, but they got it wrong. The second thing is, I believe that charter schools are state actors, at least if they receive any public funds. It may be they're run by private institutions, but if you receive public money, you should be I mean, I don't care whether you call them private schools or not, because they have private elements and public elements. But if you receive public money, that's what the problem is. And so I think they can be called state actors on that basis. The third thing I wanted to strongly disagree with is your statement that the Supreme Court cares a lot about precedent. The current Supreme Court does not care about precedent, and maybe it seems that a lot of people here don't like the Warren Court and before interpretation of the Establishment Clause requiring a separation of church and state, but I clerked for the Warren Court, and when I went to law school, separationism was the doctrine, and we all believe whatever we learned in law school, I think. So I'm a separationist, which makes it hard to teach religion and the First Amendment these days. But I do think it is remarkable that what the Establishment Clause required during the 20th century is now unconstitutional. Instead of just maybe being in neutral, that states could do it either way, maybe, or something like that. Anyway, I don't think they care about precedent. As to my comments to Mike, I definitely believe, and it has been true throughout this century, that it is constitutionally permissible to give money to religious schools. And I don't see any reason for treating charter schools any different than voucher programs or religious schools as such. But the big leap that the Supreme Court took, and I don't think it took it until Carson versus Macon, it certainly didn't openly take it until Carson versus Macon, was to not care about the uses to which the religious institution can put these funds. To evangelize, to spread their religious doctrine, to disparage other religious doctrines, and to discriminate against students who didn't follow their religious beliefs. That is much more extreme than saying that you just can't exclude religious schools from public benefits. So I guess that's all I have to say.
All right, so.
May I respond?
Yes, you may.
First, I want to respond to your question and about the South Carolina case in the Wall Street Journal. And, you know, I have a few gray hairs in my beard, especially white hairs, I guess. So I learned a long time ago not to respond fully until I know more about the case. So, but I think, as you said, you used, and I really appreciate that you said it appeared in this morning's Wall Street Journal, which I have yet to read, and I learned a long time ago not to respond until I have fully read the article in the context, but I very much appreciate your word interesting, because it is very interesting in the context of what we are discussing today. Regarding your points, and I can't address them all, but I will address probably the two that are the most important. And the first being that you disagree with me that the U.S. Supreme Court on, precedence is a big issue. Now, I totally understand, because I was raised in a similar era when the Warren Supreme Court reigned supreme, and on certain cases I really strongly agreed with them. I mean, Chief Justice Warren was actually, he was appointed by President Eisenhower by a Republican, and
So was Brennan.
and he also was, he was, of course, the Chief Justice in the Brown decision. I mean, there are a number of decisions that I strongly agree with. And I can totally understand, as someone who was raised in New York by two parents of largely your views, and my views had been your views, I can totally understand how someone being brought up in that era would interpret some of these recent decisions as well, but you're not as honoring president. Now, having said that, I can totally understand that someone might interpret it, well, they don't honor president, but it takes a lot to overturn some of the previous cases, and they have to have some legal background, if you
What
will,
about
or
Dobbs?
establishment. Well, that's what I'm saying. They feel that, they establish, and what I'm saying is I'm not denying, of course, they're going to overturn certain cases and so forth, but I'm not saying in every single case there's nothing that can be overturned, and I totally understand that being brought up in that era, you might have a different interpretation. I totally respect that. Again, that was my previous view. Having said that, though, I'm not saying that they never overturn a case. I'm just saying over the broader history and the longer history of the U.S. Supreme Court, there is this trend that, and I think it's still intact, we might disagree on that, but I think largely that they honor that. So I respect you, but agree somewhat, but not entirely. And on the other issue, whether those who run the charter schools are state actors or are they private actors, I also totally respect, as I said, that is the third issue that needs to be decided by the U.S. Supreme Court. Do I lean, as you do, that they're probably going to decide that religious charter schools are constitutional? We agree on that. But I would be the first to admit that is the key issue, and am I 100% certain that they will decide that they are private actors? I'm not 100%, but that is my leaning, that they will likely decide that way. And if they do, and I can see the other side, I mean, there's a reason when courts of appeal in the 4th and 9th districts are in disagreement. There's reason for it, and I think some of the debates that go on, in fact, when I teach my students, I say the same thing. If debates have been going on for decades and even centuries, there's a reason, and the reason usually is both sides have a valid point. So I would say, if you believe that they're state actors, that's a very valid point. I just think that in the end, and we agree on this, the Supreme Court will decide that they're private actors, and that will lead them to make the decision that religious charter schools are constitutional. So,
Well, before we go on to Mike, can I just interject the Zellman case? I was at the Supreme Court building that day. I was very pleased to see my own work cited in the concurring opinion by Sandra Day O'Connor, which turned out to be the controlling opinion because it was a 5-4, and the concurring opinion was crucial to the 5th vote. And so Sandra Day O'Connor actually, the court does not overturn Nyquist. They sort of interpret what was going on in Cleveland, which was money going to Catholic schools and other religious schools, although it also went to secular schools. They said, well, okay, you can do this in Cleveland because it's for poor kids whose education isn't very good. So the purpose was educational and not religious. So Do you see Zellman as one of those precedents that can be cited in either direction, but does give them, so the whole question of precedents is some of those precedents are, interpretable one way or another. So maybe you all can sort of factor that into your comments as you go forward.
Yeah, well, and I think, but the crucial thing in Zellman was that unlike in Nyquist and Lemon and some of the other cases from the 1970s, the state wasn't writing a check to the school for teacher salary supplements, which was the issue in Lemon, for example. But instead, the state was engaging in an aid program that then was the beneficiary of students and parents who then exercised independent choice to use that at a religious school. And that's what Chief Justice Rehnquist said severs the connection between state funding and where the dollars end up. That means there's no Establishment Clause violation there. Now, it is tricky in the charter school context because that's a tougher issue, I fully acknowledge. And the proponents of my view, the view that they're constitutionally permissible, have to rely on the fact that, well, there's still parental choice going on because the aid formula for how much the charter school gets, its enrollment, is determined by the choice of parents as well. But it's a gray area. I would suggest potentially between the kind of Zellman independent choice view and the view that the state can't just simply write a check to schools. And I'll just very quickly, just for issues to people to chew on a little bit. I think one thing, I'm worried, Professor Phil, I think it's overstating it to say that once you receive public funds, you become a public entity. So private religious hospitals don't become public entities by virtue of taking Medicare and Medicaid reimbursements. And I do think there are lots of instances in which we see cooperation and accommodation in social service context, healthcare context, and education, where entities can receive public money but aren't thereby transformed into public institutions. And finally, about Carson versus Macon and the view that that Maine only disallowed pervasively sectarian participants in the program. That language, I think that engages in a kind of denominational preferentialism that I think itself the First Amendment doesn't allow. And this came up at oral argument when Justice Alito said, well, what if you had a Unitarian Universalist school that didn't have a lot of kind of religious dogma and had a lot of ideas about equality and toleration and things like that? And the advocate for Maine said, well, that would be fine. And they said, well, what about an Orthodox Jewish school? And he said, well, no, you couldn't do that, right? Well, that decision of, well, who counts as too religious or not religious enough, or what kinds of religions can participate in the program, and what kinds of religions can't, I don't think the First Amendment allows that kind of preferentialism.
And I would agree. I don't think you can, I think it's clear by decisions by the U.S. Supreme Court that you can't cherry pick that way. And to piggyback on the Zellman case, the point that you make is also very valid. But there's another issue, too, that was apparent in that case, and that is that one reason why that was ruled as constitutional is because given that the parents and the families were the beneficiaries, it was up to them whether they wanted to send their children to non-religious private schools or religious private schools. They could make that choice. There was still the availability of non-religious schools, and had that not been the case and it only been religious schools, then I think the court would have ruled differently. And you could almost say that some of these issues that we're dealing with today are much the same, except in reverse, if you will. Before, it was important that, hey, we need to include the non-religious private schools as well. And now it's almost working in reverse that, well, if that argument applied, is it not also logical, and of course that's the question, to say that it is discrimination to say that only non-religious schools would be considered in a program? So I think it's a very interesting question, and the effects of Zellman.
Okay,
So thank you.
have
I know there are questions in the audience, but I want to give Professor Field the last
I
comment
just want
here.
a quick reply. It's true that the Supreme Court in these cases, especially as they were transitioning from separatism to a neutrality point of view, put a great deal of emphasis on whether the check was written to the parents and then the parents gave it to the school, or whether the check went directly to the school. I frankly thought that was a silly distinction. I mean, it's true parental choice is relevant, but if it's parental choice I don't think it makes any difference whether you give the check to the parents to give to the school or the state gives the money directly to the school. The other thing about Zellman that distinguishes it from what we're thinking about now is that in Zellman they said it was a voucher program, and the court said it was all right to have a voucher program that allowed parents to send children to religious schools. It was all right to have it. The difference now is the court is saying that they must have a program that allows parents to send children to religious schools. So it's much more restrictions on state choice. And they're saying it's compulsory to include religious schools. Now that's something I don't disagree with very much, though it's contrary to the separationist ideology. But it's putting the money to use of indoctrinating religion in all of the students. Of course, many students go to these schools because they're the best schools. And many of the students who go are not Catholic. Most of the schools we're dealing with are Catholic schools. They're not Catholic. And so to allow the schools to proselytize towards them, to teach religious doctrine, to make them follow their own religious rules, it seems to me that's a very big step. I do agree that the Supreme Court will take that step, but I think it should have stopped one step short of that, as it had in the prior cases.
All right, Michael. Another Michael.
So my question is, I think for Professor Moreland, I'm interested, that example that you just gave where they asked the litigant in the case about the sort of nominally religious school versus the one that is much more likely to practice or proselytize. So I'm interested in when a state establishes a charter school law, and obviously they vary across the states, but there are certain things that charter school laws oftentimes will say, like if there's an absence of space in a school, you have to use a lottery, or states have accountability systems that say you have to test your students and report, the grades. Do you envision a lot of litigation if the court goes in the direction that you think it does, where ostensibly neutral rules that apply to all charter schools, you're going to have some of these more religious schools saying, well, that violates our free exercise rights for some reason, and what's going to happen in that case?
No, I agree. It's the next big question. It's already been teed up in Maine because Maine did start implementing more restrictions on the participants in that program, and it gets into and it would take hours to unpack this doctrine of unconstitutional conditions. Basically, what conditions can the state put on a recipient of a benefit without that recipient being asked to violate a constitutional right, or the state violating that recipient's constitutional rights. And so as to that, I think like neutral curricular requirements, you have to teach science and history and whatever, those kinds of things. The trickier question, and we've already kind of teed it up, would be issues about admissions, hiring. Do the participants retain what we call the ministerial exception, for example, that they can make employment decisions about their teachers? I think that in those instances, I think some of those would violate the doctrine of unconstitutional conditions, but I think that the more neutral requirements about the curriculum, testing requirements, reporting requirements, things like that, I think are less problematic. And where you draw that line, I think, will be a hard question.
All right, a question over here. Yeah.
I don't think I heard any of you cite the charter Peltier versus charter day school case from the Fourth Circuit on whether charters are a state actor or not, and the court declined. Maybe someone denied it, but and the court declined to hear that to settle the question. So I'm just interested of your take on that. Why you didn't either mention it, or if you don't think it's relevant, or if it doesn't tell us anything about the disposition of the court.
I very much disagree with Bill on this question because he said that this was a central question. I think it doesn't matter whether you call them private or public. There's some of both. And it seems we ought to deal with the reality of the situation rather than which way you label it.
Yes, just to follow up on that. And very good question. And, Michael, very good question. That's why I mentioned that as kind of issue number 2 that the court must deal with. Will they be able to deal with everything? Probably not, but very good question. And very good question over here. Yes, I did very briefly refer to that case as going a different direction than the Ninth Circuit to basically say different courts of appeal, and I like to deal with finalized cases as opposed to cases that are in the process. So they went a different direction, and that's why we have this ongoing debate. As my esteemed colleague disagreed with me, I guess I'll disagree with her that I think, and there were a lot of people out of the Brookings Institution, which is not even especially favorable to this issue, but they've said, you know what, this is the core issue, whether those that run the charter schools are regarded as private actors or state actors, and we'll see how they decide. But I really do think that will, and again, I'm in very good company from some of the leaders on that this is the key issue. But again, I respect those who would disagree.
All right, so a question here and a question way over there. So we'll start here and then go over there.
Just to piggyback on the question on Peltier, is there a case that you're referring to when you say that we'll see how they decide? Do you think that's...
Oh, the U.S. Supreme Court.
No, I understand, but is there a case that the Supreme Court is currently considering or that you see them considering that will address the state actor issue again? Do you see it potentially coming through a case from Oklahoma or somewhere else? I just was wondering if there was something I'm missing.
Also a very good question. Love these questions. They're excellent. We'll see. Oklahoma might be the case that they decide to take up, because it's one of these it's gone back and forth. You really do have to read the Wall Street Journal every day to keep up with these things, because the former Attorney General O'Connell was in favor of it, and then the new one came in, Drummond, who really fought strongly against it. The charter school board initially didn't like it. The initial ideas of the St. Isabel of Seville Virtual Catholic Charter School, which was supposed to accommodate 500 students. Just referring to that in case there may be somewhere more familiar with that case than others. And then after revisions, the charter school board voted 3-2, yes, we're going to do this. And then it went to the Oklahoma Supreme Court, and it was voted 6-2 with one recusal that it was not constitutional. And I think it's going to be very interesting, because James Winchester, who wrote the majority decision 6-2, he said, well, no, it can't be accepted as into the charter school program because charter schools are public. But kind of interesting, because then we had a disagreement coming from another one of the justices. She wrote the main write-up in opposition. Dana Kuhn wrote that, you wait, this is going to go up before the U.S. Supreme Court. So if you were to ask me, is there a case out there now that very possibly would be the case where the U.S. Supreme Court decides on this? My best guess of the cases now available would be yes, Oklahoma, but they may pass and wait, so we'll just have to see.
And
But
we'll
very good
find out
question.
in October
Yes.
which cases they're deciding to review, so we'll find out then.
Chris Neely, South Carolina Public Charter School District. I'm the superintendent, and we're very familiar with what the Supreme Court did in South Carolina yesterday. Article 11, Section 4, no money shall be paid from public funds, nor shall the credit of the state or any of its political subdivisions be used for the direct benefit of any religious or other private educational institution. Additionally, the South Carolina Charter Act prohibits religious charter schools. My question, 2 questions. 1, do you see the potential, if the Supreme Court rules in favor of the Catholic charter school, of a 10th Amendment challenge by the states because of constitutions like South Carolina? Secondly, second question, do you also see that this could open the opportunity for local public school districts to then open religious public schools in their communities? Because you've got a lot of communities in America who have that ability. Thank you.
It seems to me religious public, well, that's a very big step that hasn't been taken yet. But as to your first question, Oh, yes. Many state constitutions have both, some dating from the 19th century, have provisions that embody the separationist view. And they have been largely ignored. Lately, they've been ignored by the Supreme Court. That is a state constitutional provision that is inconsistent with the U.S. Constitution, is unconstitutional. And I think if the Supreme Court comes out the way we think they will in these cases, they would say it doesn't matter what the state constitution says. The federal constitution says that you have to include religious schools.
I think it's clear the state cannot directly run and administer a religious school. It can fund religious schools, and a lot of states do fund religious schools. I think the charter law is potentially unconstitutional by virtue of excluding religious participants in an aid program. And then, as Professor Field says, then it's a question of these so-called Blaine amendments. That was the federal amendment, the Blaine amendments in the states, product of 19th century anti-Catholic bigotry, and whether or not they exclude all private participants, in which case, okay. But a lot of people aren't going to be happy with that, because it means that no funding for vouchers or tuition scholarships at any private actors, and a lot of people want those choices. Or just religious participants, and that's what Carson in those cases say, that's what the Free Exercise Clause doesn't allow.
All right, so
And
way over there in the corner.
I want to just take a 50, 60,000 foot view of, I've watched the charter school community and movement sort of fumble around the state actor, private actor argument. Give me your best case or just best argument on this question, because I hear it a lot from reporters, from charter advocates, from even homeschoolers. Why not, instead of pursuing the charter route, why not stay private and get behind expanding ESAs or vouchers? Each of you, I'd love to hear that answer. Thank you.
And I'm a torts and con law person. I'm not an education policy or law person. My understanding is that my home state of Minnesota started this revolution. It was a way of not going the full voucher route in a way, but having these kinds of choices in the charter school space. But you're exactly right. Why are they public or private? States call them public schools, but if you're contracting with a for-profit and not-for-profit corporation, like I said, Boeing isn't a public entity just by virtue of having a government contract. So, but I think my understanding at least is that's why charter schools became this non-district school, district operated alternative that is, in my view, private government contracting.
Yes, and I think you raise a very valid point, going a little bit of a different direction, and I appreciate that. Even though I believe religious charter schools are constitutional, I take into major consideration the words of Kathleen Porter McGee, who runs a network of Catholic schools. Let me give you a couple of her quotes. She said, it could, meaning going this route, entangle religious schools with excessive bureaucracy. She also warns, in order for religious school funding, we would be knowingly be giving up autonomy in exchange for what would likely be excessive government bureaucracy and regulation. And I think wherever someone falls on this issue, even if they are in favor of religious charter schools, we need to be really careful. And maybe those of us who are in favor of it might say, hey, can't we do this faster? But maybe it should go step by step, and we need to be very cautious about doing this.
All right, we got time maybe for a couple more. Why don't we pick up 2-3 questions, and then we'll give people a final chance. Yeah.
Thank you for this discussion. I heard it mentioned a few times, either past considerations or discussions on whether or not certain religious schools or entities were discriminatory in their practices, and whether or not that, I couldn't follow everything, but whether or not that factored into whether or not they were approved for being part of these programs or not. My question to anyone on the group, maybe specifically for Professor Field, is have you seen anything of late or recently that has to do with defining those practices or those discriminatory positions. And the context for this question is I know many religious schools where I am from in Wisconsin have pretty strong core values that I think, depending on who you ask, may very well seem discriminatory. I don't know that any are particularly leading marches or hating people per se, but depending on who you ask. So my question is, what sort of definitions, thresholds, et cetera, have you seen in the past? And is that something that's you see on the horizon being a factor for approval of religious schools, et cetera?
Well, I think from what we anticipate from the Supreme Court whenever they decide it, is that they would not be a factor. But what we're talking about is a school that that teaches that belief in Jesus is the only way to get to heaven, or
Salvation.
salvation. Sorry. And when they have students who clearly are raised in different religious environments. I mean, it's true that some things that are just about values, you could say they're about religion, but you can say they're just about values. I guess a sort of borderline case would be the Catholic Church on reproductive rights. But the Supreme Court did decide in a decision where there was a public program to assist pregnant teenagers that it was perfectly all right to have the Catholic Church as an administrator of that program. So yeah, there would be difficult decisions. Just one other thing. Something Bill said reminded me that separation of church and state, which we don't have right now, but the purpose was to protect religion as well as to protect non-believers. And there still is some worry that if we're not having any separation, that that religions will feel that they need to compromise their own values and their own policies in order to get government grants, for example. So the separationist view was to protect dissenters from the religion being imposed upon them, but also to protect religion from the state.
Our last question here. Yeah.
So you're talking about private and public actors, parents making decisions. So I'm going to give you an example. So I attended a public school in the great state of Maine on the Canadian border. We had nuns teaching in the public school. It was a district school. And on Wednesday mornings, the Catholics had CCD classes. And we were flooded with more nuns and priests in the Catholic school. Parents could opt out. And then a border patrolman moved in from outside, and his family was Baptist. And so Ms. Flewelling went to the dining hall and had her Baptist class, whatever that was. And on the school schedule, it said we were all taking ethics classes. And so not surprisingly, at some point, the Department of Ed got a hold of this and came up to visit. And I doubt they're probably still doing this quite the same way. But I do have a question, given the current state of things, or what you anticipate happening, is what happens in a situation like that?
What happens?
What happens in a situation like that?
Oh,
I think under the Warren Court, it was pretty clear
One
that should not be
thing,
happening.
The Warren Court didn't allow
Right, absolutely.
religious persons into public schools. And there's lots of things the Warren Court ruled, like no prayer in public schools,
Right. And
no
so
Ten Commandments posted, that one wonders once the change starts happening, whether those decisions will hold
Well,
up.
and I think that's my question, is because under the Warren Court, it was pretty clear. I was going to say we're hiding out in public, but when you live 4.5 hours north of Bangor, not too many people are coming by. But now I start wondering if this kind of situation can start happening in more and more places.
Well, I think we have to be careful. And, just even as in the quotes that I just described, and I think there is maybe some wisdom in going about this slowly because it does need to be done carefully. Now, keep in mind that's a public school, and we're talking charter schools, and that's why the public versus state actor is important. But it's also true that some of the members, Bill Clinton actually noted this. He said in a speech in 1995 in Vienna, Virginia, he made a speech that says, look, we've taken some of the Supreme Court decisions out of context, because, for example, the Abington versus Schempp, which is one of the 3 cases in terms of bringing Bible out of the schools, it said we're not discouraging a study of the Bible. It just needs to be in a way that does not proselytize. It's the most published book in the history of humanity. And you can really make an argument that in order to understand other pieces of classical literature and even our history, a working knowledge of the Bible is important. I was raised an atheist, okay? I'm not an atheist now, but that's the way I was raised. And even my mom said, you need a working knowledge of the Bible because of its influence in history. So Bill Clinton made it clear there needs to be the study of the Bible in our schools. That people have, taken these cases and gone to, have gone too far with them, and there needs to be more of a balance. So I would use the word balance, and again, to remember, these are charter schools that we're talking about, and this is why I think the ruling on whether these are private or state actors is exceptionally important.
But the separationists also always said that it was fine to study the Bible in the public schools as long as it wasn't part of a religious exercise.
And we're agreed.
Right. It's very dangerous to read the Bible. There's all kinds of stuff in there you might find yourself in disagreement with. So
you might get saved.
But do stay for the next event because we have a terrific personality. Alberto Carvalho is somebody I've known for a long time. He was outstanding superintendent in Miami. He has got a tremendous challenge in Los Angeles, and I think you're just going to find him a fascinating way to end up the afternoon. So take a little break now, but come back for our final session.